If you are a United States citizen trying to bring your brother or sister to America, stop what you are doing right now and pay close attention, because what I am about to share could save you literally years, perhaps even a full decade of waiting. The truth is that most people who file sibling petitions are making critical mistakes that cost them precious time, and worse, many do not even realize that faster alternatives exist which could bring their family members here in a fraction of the time. By the end of this presentation, you will know exactly how long the real wait times are, why those waits are so incredibly long, and most importantly, you will learn proven strategies that could reduce your waiting period from 20 years down to just 3. So if you care deeply about reuniting with your siblings, you cannot afford to miss what comes next. Hey everyone, welcome back to US Visa Info, the channel where we break down everything you need to know about United States immigration in clear and straightforward language. I am here to help you navigate the complex world of immigration law. And today, we are tackling one of the most common questions I receive every single week from viewers just like you. How long does it actually take to sponsor a brother or sister to move to the United States when you are a United States citizen? And more importantly, what can you do about these insanely long wait times? Before we dive deep into the details, I want to set proper expectations right from the start. We are talking about processing times that can stretch anywhere from 8 years to over 2 decades, depending on various factors. I know that sounds discouraging, and honestly, it should concern you, but here is the thing. Knowledge is power. And understanding exactly how this process works, along with what alternatives exist, could literally change your family's future. So I am asking you to stay with me through this entire presentation, because the strategies I will share toward the end could be game-changing for your situation. Let us begin with the reality check that nobody wants to hear, but everyone needs to understand. As we sit here in February 2026, the processing times for sibling immigration petitions are absolutely staggering. We are looking at wait times ranging from 95 months on the lower end all the way up to 173 months on the higher end. To put that into perspective, 95 months translates to almost 8 full years, while 173 months equals more than 14 years. And here is the kicker. Those numbers can be even worse depending on where you or your sibling were born. If you or your brother or sister were born in the Philippines, Mexico, China, or India, you need to brace yourself because the wait times for these countries are significantly longer due to per-country limitations and the sheer volume of applications from these nations. We are talking about wait times that can easily stretch into the 20 to 22-year range. Yes, you heard that correctly. 2 full decades. That means if you filed a petition today for your sibling from one of these countries, they might not set foot in the United States until the year 2046 or even later. Think about how much life happens in 20 years. Children grow up, parents age, opportunities come and go, careers are built or lost, and family bonds are tested by distance and time. This is precisely why understanding the process and exploring every available alternative is so critically important. Now let me walk you through the general process so you understand exactly what we are dealing with here. The sibling sponsorship process follows a specific pathway that involves multiple government agencies and several distinct phases. First, you need to file Form I-130, which is the petition for alien relative. This is the foundational document that establishes the relationship between you as the United States citizen petitioner and your sibling as the beneficiary. Once filed, you will need to track the processing times through the United States Citizenship and Immigration Services system. But here is where it gets tricky. Even after your I-130 is approved, your sibling still cannot immigrate immediately. They must wait for what is called their priority date to become current according to the monthly Visa Bulletin published by the Department of State. Finally, when everything aligns, your sibling will attend an interview at a United States embassy or consulate in their home country, and if approved, they will receive an immigrant visa that allows them to enter the United States and receive their green card. Sounds straightforward enough on the surface, but the devil is in the details, and those details are what create these massive backlogs and extended wait times. Let me explain why these petitions take so incredibly long and what factors are at play here. The United States immigration system operates on a strict quota basis for family preference categories. Unlike immediate relatives of United States citizens, such as spouses, parents, and unmarried children under 21, siblings fall into what is known as the F4 category, which is the fourth family preference category. This category has an annual limit on how many visas can be issued, and that limit is approximately 65,000 visas per year for the entire world. When you consider how many United States citizens have siblings they want to sponsor, and when you factor in that many of those siblings themselves have spouses and children who are included in the same petition, you can quickly see how 65,000 visas per year is nowhere near enough to meet the demand. This is where the priority date system comes into play, and understanding this is absolutely crucial. When you file your I-130 petition, the date that United States Citizenship and Immigration Services receives your petition becomes your priority date. Think of this as your place in line. The Department of State publishes the Visa Bulletin every single month, and this bulletin tells you which priority dates are currently being processed for each category and each country. The Visa Bulletin moves forward slowly over time as visas become available and cases are completed. So even if your I-130 petition is approved relatively quickly, let us say within 2 to 3 years, your sibling still cannot take the next steps in the immigration process until the Visa Bulletin shows that your priority date is current. Right now, in February 2026, the Visa Bulletin for the F4 category is processing cases with priority dates from around 2011 or 2012 for most countries. For countries with higher demand like Mexico, the Philippines, India, and China, the dates are even further back, some going back to 2004 or 2005. This means that applications filed today will not be current for another 14 to 22 years based on current processing trends. It is a sobering reality that catches many people off guard. Let us talk about the actual I-130 processing times, because this is the first hurdle you will encounter. Currently, processing times for Form I-130 vary significantly depending on which United States Citizenship and Immigration Services Service Center is handling your case. We are seeing processing times ranging from 17 months to 60 months, depending on the center and the specific circumstances of your case. The agency has different service centers across the country, including locations in California, Texas, Vermont, and Nebraska. And each center has different processing speeds based on their current workload and staffing levels. You might be wondering how you can check the status of your I-130 petition once you have filed it. The process is actually quite straightforward. You go to the United States Citizenship and Immigration Services website at USCIS.gov and navigate to the Case Status section. Every I-130 petition receives a unique receipt number, which you will find on the receipt notice that United States Citizenship and Immigration Services sends you after they receive your petition. This receipt number is typically located in the upper left corner of the notice. You enter this number into the Case Status tool, and it will show you the current status of your petition, whether it has been received, is being processed, requires additional evidence, or has been approved. But here is what you need to understand, and this is where many people get confused. Even when you see that your I-130 has been approved, that approval does not mean your sibling can immigrate immediately. The I-130 approval simply establishes that you have a valid qualifying relationship with your sibling and that you meet the requirements to petition for them. The real waiting game begins after approval when you are monitoring the Visa Bulletin month after month and year after year, waiting for your priority date to become current. I want to talk about some of the common reasons why sibling petitions get denied, because yes, these petitions do get denied, and understanding the pitfalls can help you avoid them. One of the most frequent reasons for denial is insufficient proof of the sibling relationship. You need to provide clear documentation showing that you and your sibling share at least one common parent. This typically means providing birth certificates for both you and your sibling that show the same mother or father or both. If birth certificates are unavailable or do not clearly show the relationship, you may need to provide alternative evidence, such as baptismal certificates, school records, affidavits from family members, or DNA testing results. Another common issue is incomplete forms or insufficient supporting documentation. The I-130 form itself must be filled out completely and accurately with no blank fields unless they truly do not apply to your situation. You need to include all required supporting documents, including proof of your United States citizenship, which could be your United States birth certificate, certificate of naturalization, certificate of citizenship, or United States passport. You also need to include proof of any name changes if your name or your sibling's name has changed since birth, such as through marriage or legal name change. There is also the citizenship requirement that trips people up. Only United States citizens can petition for siblings. If you are a lawful permanent resident, a green card holder, you cannot file an I-130 for your brother or sister. This is a hard and fast rule with no exceptions. You must be a United States citizen, and you must provide proof of that citizenship with your petition. Additionally, you must be at least 21 years old to petition for a sibling. If you are under 21, even if you are a United States citizen, you will need to wait until you reach that age before you can file. Let me take a moment here to explain why I am so passionate about making sure you understand all of this information. I know these wait times are frustrating, incredibly frustrating. The idea of waiting 15 or 20 years to reunite with a brother or sister feels almost cruel. But the more you understand about how the system works, the better equipped you are to make informed decisions about your options. And that is exactly what I want to talk about next. The alternatives to the traditional F4 sibling petition that could potentially get your family members to the United States much, much faster. Here is where things get interesting and where many people do not realize they have options. If your sibling has education, professional experience, or specialized skills, they may qualify for employment-based immigration categories that have significantly shorter wait times than family-based petitions. I am talking about categories like the EB-2 National Interest Waiver or the EB-1A for individuals with extraordinary ability. These categories allow your sibling to self-petition, meaning they do not need a job offer from a United States employer. And in many cases, they can get their green card in as little as 2 to 3 years, instead of 15 to 20 plus years. Let me give you a real example to illustrate this. I recently worked with a family where a United States citizen had been waiting 9 years for his brother's F4 petition to process. 9 years in, and they were looking at another 13 years of waiting based on the Visa Bulletin movement. The brother, who I will call Mauricio, was living in Mexico and working as a scientist. When we looked at Mauricio's background more carefully, we discovered he had a master's degree, had published research papers, was working in a critical role in his industry involving innovation and technology, and was earning a substantial salary that reflected his expertise and contributions to his field. We took all of this information and built a case for an EB-2 National Interest Waiver. This category is for individuals who can demonstrate that their work is in the national interest of the United States, that they are well positioned to advance their proposed endeavor, and that it would be beneficial to the United States to waive the normal requirement of a job offer and labor certification. We compiled evidence of Mauricio's publications, his letters of recommendation from colleagues and experts in his field, documentation of his salary and position showing he was recognized as a leader in his area, and a detailed plan for how his work would benefit the United States. The petition was approved, and Mauricio is now on track to receive his green card in approximately 3 years from the date of filing, instead of the 22 years he was facing through the F4 category. That is a difference of 19 years. 19 years of his life he gets back to pursue his dreams and be with his family. This is not an isolated case. I have seen similar success with individuals working in technology, healthcare, business, education, engineering, and various other fields. The key is understanding what qualifications and evidence are needed and presenting them in a compelling way that meets the legal requirements of these categories. If your sibling has a bachelor's degree plus 5 years of progressive experience in their field or a master's degree or higher, they may qualify for the EB-2 category. If they have achieved national or international recognition in their field, have extraordinary ability demonstrated through sustained acclaim, or have achievements that have been recognized through extensive documentation, they might qualify for the EB-1A category, which can be even faster. Now, I want to be clear about something. Not every sibling will qualify for these alternative pathways. These employment-based categories have specific requirements, and not everyone meets them. But here is what I have learned over years of practice. Many more people qualify than realize it. People underestimate their own achievements and qualifications. They do not think they are special enough or accomplished enough to qualify for these categories. But when you work with an experienced immigration attorney who knows how to properly document and present a case, you would be surprised how many people do qualify. The other advantage of employment-based categories is that they are not subject to the same severe per-country backlogs as the F4 category. While there can be wait times for certain countries in certain employment-based categories, they are generally much shorter than the family-based F4 times. This is especially significant for individuals from Mexico, the Philippines, India, and China, where the F4 wait times are the most extreme. So what should you do with all this information? First, if you have already filed an I-130 for your sibling, do not abandon it. Keep it active. Continue to monitor your priority date through the Visa Bulletin. Make sure you update United States Citizenship and Immigration Services with any changes of address so you do not miss any important notices. Even though the wait is long, it is still a valid pathway, and you never know if immigration laws might change in the future to reduce backlogs or increase quota numbers. Second, explore whether your sibling might qualify for an employment-based category. Have an honest assessment of their education, work experience, achievements, salary history, and professional recognition. Gather their resume, their diplomas, any publications or presentations they have done, awards they have received, and letters of recommendation they could obtain. Then consult with an experienced immigration attorney who can evaluate whether they might have a viable case for an EB-2 National Interest Waiver, EB-1A, or other employment-based category. The consultation fee is a small investment compared to potentially saving 15 or 20 years of waiting. Third, understand that immigration planning requires patience and strategy. These are not processes that happen overnight. Even the faster employment-based categories take time. You need to gather evidence, prepare a strong petition, wait for processing, and go through all the necessary steps. But the difference between waiting 3 years and waiting 20 years is monumental. It is the difference between your sibling being here to see their nieces and nephews grow up versus missing most of their childhood. It is the difference between your sibling being able to care for aging parents versus only being able to visit occasionally. It is the difference between building a life together as a family versus decades of separation. I also want to address something that comes up frequently. Some people ask whether there are ways to speed up the F4 petition itself. The honest answer is that there is no magic button to skip the line. The Visa Bulletin moves at the pace it moves based on demand and quota numbers. However, there are things you can do to make sure your case does not experience unnecessary delays. Make sure your I-130 petition is complete and accurate when you file it to avoid requests for evidence or rejections. Keep your address updated with United States Citizenship and Immigration Services so you receive all notices promptly. Respond quickly to any requests for additional evidence. And when your priority date becomes current, make sure all your supporting documents are ready to go so you can move through the National Visa Center processing and embassy interview stages as efficiently as possible. All right, everyone. We have covered a lot of ground in this presentation, and I want to thank you for staying with me all the way to the end. We have talked about the harsh realities of F4 sibling petition processing times currently ranging from 8 to over 20 years, depending on your country of birth. We have walked through the entire process from filing the I-130 to tracking your priority date through the Visa Bulletin to finally attending that embassy interview. We have discussed common reasons for denials and how to avoid them. And most importantly, we have explored alternatives to the traditional sibling petition that could potentially reduce your wait time from decades down to just a few years. Here is what I want you to take away from this. Yes, the F4 category has extremely long wait times, but understanding the system empowers you to make better decisions. And for many siblings, there may be faster pathways through employment-based categories if they have the right qualifications. Do not assume you do not qualify for alternatives without having a proper evaluation done. If you found this information valuable, I need you to do a few things for me. First, hit that subscribe button and click the notification bell so you never miss an update from US Visa Info. We put out content every single week designed to help you navigate the immigration system successfully. Second, give this video a thumbs up. It helps the algorithm show this information to more families who desperately need it. Third, share this video with anyone you know who is going through the sibling sponsorship process or thinking about starting one. Knowledge shared is power multiplied, and if you want personalized guidance for your specific situation, I encourage you to reach out for a consultation. Every case is unique, and while these videos give you general information, there is no substitute for having an experienced immigration professional review your individual circumstances and create a customized strategy for your family. Whether you are looking to move forward with an F-4 petition, explore employment-based alternatives, or you have questions about any other aspect of immigration, we are here to help. Remember, immigration is a marathon, not a sprint. It requires patience, persistence, and proper planning. But with the right information and the right strategy, you can reunite with your loved ones and build the future you have been dreaming of in the United States. Thank you so much for watching US Visa Info. I will see you in the next video where we will continue breaking down everything you need to know about United States immigration. Until then, stay informed, stay hopeful, and keep moving forward toward your immigration goals. Take care, everyone.